Good morning, ladies and gentlemen. It is very pleasing to see such a good turnout on this morning. Before we start the proceedings, I would like to acknowledge the traditional owners of the land on which university stands, Berrigal and Gadigal people, and their elders past and present. And now it gives me a great pleasure to introduce Professor Vanessa Lem, the Head of School of Humanities and Languages, to address you with a welcome. Vanessa.
Thank you very much, Ludmila. So, good morning and welcome to our symposium, Achieving Quality in Court Interpreting in Australia. It is a great pleasure for me to be able to say a few words to open this symposium. Court interpreting is one of the most demanding and visible forms of interpreting on which depends the application of a fundamental principle in any courtroom, namely, to be able to listen to the other part. In my view, interpretation is a fundamental building block of showing the common nature of language, and court interpreting has the additional task of making possible something like justice by allowing for the principle of listening to the other. The theme of this conference, namely how to continue to improve the quality of court interpreting, is thus of utmost relevance and importance today. In our globalized but not yet truly cosmopolitan world, the need to raise the bar of interpreting quality is not only of importance in Australia, but is an international challenge that pertains to interpreting in domestic and international courts in a wide range of countries all over the world. The focus of this symposium is to ask what are the external factors that impact on the quality of court interpreting, and how can we move forward? How can these external factors be improved, and what role do the many stakeholders play? I welcome all of you who flew in from interstate and even from overseas. A special welcome goes to Mr. Nicholas Cowdery, former Director of Public Prosecution of New South Wales and a Professorial Fellow at the University of New South Wales, as well as to Ms. Alexandra Tomic, Chief of Interpreting and Translation Unit at the International Criminal Court in The Hague. I am sure that their impressive combined experience in matter of law and interpretation will greatly enrich these proceedings and be very stimulating for all the participants. It is a great honor for us to have them here today with us at UNSW. I also want to take this opportunity to thank Professor Sandra Hale and Associate Professor Ludmila Stern for organizing the symposium. Events such as these are not only essential for our academics and interpreting students who seek to enrich and extend their research experiences. They are also of importance to all those of you who are from the profession, interpreters and legal professionals who wish to continuously improve and excel the quality of their practice. Events such as our symposium are so valuable for us because they open up a space for reflection, vivid discussion, and exchange of ideas. I wish you a wonderful, productive, and inspiring day, and leave the word to Ludmila Stern.
Thank you very much. Thank you very much, Vanessa, for your warm welcome. And now I would like to invite Mr. Nicholas Cowdery, Order of Australia, Queen's Counsel, the longest-serving Director of Public Prosecutions of New South Wales. I think there is no need to say too much about him, because anyone in Australia who had anything at all to do with law, with courts, with legal interpretation, has been aware of his crucial role and his leadership in his past and current positions. Mr. Cowdery continues to serve on a number of national and international organizations. He is a consultant, he's a spokesman for human rights. And it gives me a great pleasure to invite him here now to talk about his views on court interpreting, including his personal experience. Mr. Cowdery.
Well, Well, thank you, Ludmilla, for that generous introduction, and good morning, ladies and gentlemen. I'm the warm-up act. I'm the light relief before you get down to the serious business of this symposium. So I hope you will bear with me for a few minutes while I do as Ludmilla has foreshadowed. But I do wish to thank you and the organisers most sincerely for inviting me to address this important symposium today. I see from the programme that you will be dealing with a wide range of issues of significance to your professional activities and directed towards ensuring the highest quality of interpretation and translation in the forensic context in Australia and elsewhere. And I wish you an enjoyable and productive day. Actually, I've used a word already that highlights one aspect of your work that needs to be accommodated. And I won't ask you to go back over what I've just said. What needs to be accommodated is the fact that languages, with the exception perhaps of Latin and others that have been frozen in time, are alive. They constantly change, and interpreters and translators need to be aware of that and adjust accordingly. The word I used is forensic. It comes from the Latin forensis, which means relating to the forum or the court, the place where justice was administered. And over time, we have identified certain scientific areas as having a particular relationship with the courts. For example, ballistics, fingerprints, tool marks, blood spatter, and so on. And we call them forensic sciences. Sciences related to the court. Now, the general population has not seen the word forensic used much in any other context. And typically a shortcut has been made in the use of that language to describe forensic science matters as simply forensic. And so the word has now come to be used not as relating to a court, its proper meaning, but as a synonym for scientific, even by the experts in the field. Now, being something of a traditionalist, I resisted that change for a very long time, but I'm now prepared to admit defeat. It has happened. The meaning has changed. And that and other words are some that you need to be aware of when you use our wonderful English language. I suppose it happens in all languages. But the few other English words I'd also like to mention in this context are noisome, which has nothing to do with noise, fulsome, which has nothing to do with quantity or completeness, and enormity, which has nothing to do with size. But it won't be long before they do mean all of those things that they presently don't. So you will have to keep track with that. And be careful of either overestimating or underestimating, which, depending on the context, either cannot or should not be done. And the meanings are very different. You have a lot of challenges, I know, and I'm just highlighting a few that have occurred to me. I first became aware of the importance of interpretation to the forensic process, to the justice system, in 1971. When I began working as a public defender in Papua New Guinea. I had studied Latin through to the end of school and French into university, but I was then in a country with over 700 different languages, some of them spoken by only a handful of people. And I mean languages, not dialects, and you would appreciate the difference. It was necessary to learn to speak the lingua franca, Pidgin English, in order to communicate with clients. But qualified interpreters had to be used in court and for official translations because English was the language of government and the courts. I quickly learned that kill did not mean what it sounded like. and assaults and deaths were common fare in the courts, so we use these terms quite a lot. To kill someone in Pidgin simply meant to hit. Kilimi die meant that he was hit and knocked down. But Kilimi die Pinis meant that he was hit, he was knocked down, and he wasn't going to get up because he was dead. And sometimes interpreters had to be picked up on these subtle differences if they hadn't been paying close attention and listening to all the words that were being used by the witness. And sometimes, as our facility with Pidgin developed, we lawyers would find it necessary to interrogate a court interpreter about a translation. And this became a common and easy process. An issue would be raised about interpretation of a word or a phrase. The judge would allow a voir dire examination, a trial within the trial, and the issue would be explored and resolved. I once appeared for a man accused of murder in a remote town in the jungle in the Sepik district in northwest Papua New Guinea. For the trial, we had 3 interpreters. The first to go from English, the language of the courts, to Pidgin. The second to go from Pidgin to a local language close to the area where the witness or the accused lived. And the third interpreter to go from that language to the language of the witness and the accused. It was a slow process, as you might imagine, in both directions, and I'm sure much of the subtlety of both questions and responses was lost along the way. And by the lawyers too, who by the time the answer came back would have forgotten what the question was. And the answer might not have been much of a clue. Last year I redrafted the Prosecution Code of Hong Kong, a lengthy document, and I took quite some time to prepare a first draft in English. I used the existing document, other relevant Hong Kong material and codes or policies in place in other cognate jurisdictions. I then spent a week around the table in Hong Kong with senior prosecutors and others, settling a number of drafts until we had what we regarded as a serviceable document that could then go forward. I was then informed that not only would it have to be considered by a Cantonese speaker and a Mandarin speaker to ensure that translations would be able to be accurately made, but it also had to be submitted to the government's English language expert to ensure that we hadn't lapsed into arcane or ambiguous expressions, or expressions that were not approved in government publications in Hong Kong. So that was a bit of a wake-up call. In South Africa at the moment, there's a man called Oscar Pistorius, who is on trial, as I'm sure all of you know, for the murder of his girlfriend. And it's interesting to see that even in that very high profile and important trial, there are issues of language and translation that have been raised. And I say nothing about the sign language of the interpreter at Nelson Mandela's memorial service. The South African Translators Institute has raised concerns about the standard of interpreting at the trial, referring, among other things, to a witness saying that Pistorius was highly upset at a time which was translated as simply upset. Could be a significant difference. A witness said that there were towels and black garbage bags at a particular place, which was translated as black clothing. Another witness said that the person was already dead when the paramedics arrived, and that was translated as the body died on their arrival. Another said that at that stage they had already been on duty for 24 hours. That was translated as we were 24 on duty. The chair of the institute, Johan Blau, was quoted as saying, "This kind of incorrect information being conveyed to people in court who depend on the interpreted version, which may include the judge, can have a serious impact on the eventual finding. If they are not picked up by one of the parties in court and immediately objected to or corrected, such errors are very difficult to correct later." And he has appointed a committee to explore ways of improving services. And the Chief Justice of South Africa has even chipped in, offering to have judges help with training interpreters. This all serves to highlight the importance of having high-quality interpreting and translation in the courts. Forensic processes, and I'm using the old-fashioned meaning, forensic processes are carried out by teamwork, and it's vital that every member of the team perform at his or her best. Communication is the key to achieving justice. Everybody in the process must be enabled to know the material that has to be taken into account. The words spoken by witnesses and other performers in the process, the words recorded in documents and elsewhere, the ideas being conveyed by the language used. Accuracy and completeness are vital, and in ensuring that, it might be necessary for an interpreter to examine the ideas behind the language in order to properly translate the meaning of what is being said. It's a taxing exercise, and for people like me who do not have great facility in more than one language, and sometimes not even in one, it's difficult to describe precisely how that should be done and the limits that should apply. But I'm sure that you'll be exploring those sorts of issues today. It's also vital to ensure that all members of the team in court proceedings are supported to the best ways possible. Judges are usually well provided for, although sometimes not. Counsel differ depending on their status, employment, client's means and the venue of the court. Accused persons in custody are taken care of. On bail, they have to make their own arrangements. Witnesses and victims of crime are progressively having their conditions improved. But I understand that court interpreters are doing it tough. The familiar excuse of inadequate resources is trotted out whenever there's discussion of remuneration, preparation, workrooms, work desks, relief interpreters, provisions for translation to the accused during the trial, and so on. Perhaps people in positions of power simply think that if someone has facility in another language, that's all that needs to be taken into account. But you know, and I know, that there is much more. That's why symposia like this are important. You are gathering to learn what is happening in other places. You will pool your different experiences and discuss better ways of doing things. You will learn how the conditions of interpreters can be improved to meet special demands and the practicable ways of doing that. You will discuss preparation, briefing, quality control, teamwork, and much more. You will learn from each other and emerge better equipped to take on the daily challenges that your important service must meet, to enable the court's purposes to be properly and fully realised. And may I remind you, as I have always done when I have spoken to conferences of this kind, that the discussions that take place outside the formal sessions inside this room are equally or perhaps even more important than the discussions that take place inside. That's your opportunity to network, to make contacts, to discover what is being done elsewhere and to talk one-to-one about the issues that you all face. So thank you very much for the opportunity to speak to you. I wish you all a very enjoyable and productive symposium today, and I congratulate the organisers for putting it on.
Mr. Cowdery, thank you very much, not only for the time you've given us, but for your thoughts, your experience, your very apt observations regarding interpreting quality and accuracy. Now, Sean, I might ask your help to prepare Alex's PowerPoint as I introduce her. And so, as Mr. Cowdery said, today is a day to reflect on all the factors that contribute to the quality of interpreting in court, and also to exchange experience and to find out what happens in other parts of the world. And it gives me a great pleasure to introduce our keynote speaker, Ms. Alexandra Tomic, who is the Chief of Court Interpreting and Translation Section of the International Criminal Court in The Hague, a permanent criminal court to deal with crimes against humanity, major war and other similar crimes. Just very briefly, Ms. Tomic comes from the background that did not initially anticipate her becoming involved in interpreting or running interpreting sections in war crime courts and tribunals. She started her career as an interpreter amidst the Balkan conflict in the 1990s. She happened to become a field interpreter who was traveling in the most dangerous parts of the former Yugoslavia amidst the conflict. She then was trained at the then new International Criminal Tribunal for the former Yugoslavia and became a court interpreter in the simultaneous mode in the booth. And her experience then led her in 2003 to the International Criminal Court, where she founded the then non-existent section of court interpretation and translation. And I believe that it is her experience, her vast experience as an interpreter in different modes, in different settings, but all relating to justice, that allowed her, that informed her decisions and her approach to creating the current section of court interpretation as we know it. I look forward to your talk, Alex, because I think there is a lot that we who are involved in the interpretation in domestic courts in Australia and elsewhere can learn from international criminal courts. Over to you. Forward, backward.
Thank you, Ludmila. This is a very tough act to follow. I will do my best. I'm very happy to be here today. It's a great opportunity to tell you about how we do things in The Hague. I'm sure it seems very glamorous, and that you may think that we are doing things in such a wonderful way that things can't possibly go wrong. But I think many of you who are practitioners, you know how many things do and often go wrong. Now, one of the things I want to make clear first is that the title, Quality in International Criminal Courts, it should be quality of interpretation. I do not want to be responsible for the quality of prosecutions, judgments, defense strategies, etc. So interpreters can only do so much, but they can't influence things. They can, of course, make mistakes, and we all do. But this is how I'm going to tell you how we do it, and then I hope we can have a good discussion. Now, I have deliberately chosen to say good enough and not best, because I think that when language people, and when I say language people, I mean translators and interpreters, talk about language, they tend to go for the really highest possible value of a translation of an interpretation. We all talk about the best conditions and the best practice. And that, of course, is important. But I am reminded very frequently about something that my boss often says to me. And that, in French, is, he says often, meilleur est l'ennemi du bien. Sometimes you just need to get it good enough. And this is what this is about. Now, we started in 2003. This is when the court really was founded in 2002. But we started in 2003 and there was nothing. There were a couple of translators who were recruited. We do French and English. These are our working languages. And there is always translation to be done. The court has inherited the system of the UN, and the UN languages are also the official languages of the court. The Rome Statute was negotiated over many years among many countries, even those countries that never became states parties. States parties are the countries that have signed up, ratified the statute, and have also agreed to change their legislation in order to accept the supremacy of the court. Now, there are many different things that the court does, but I will be concentrating just on the language side. And I think probably Nick Cowdery knows more about the legal side of the court than I do. Now, the language side of the court, it was interesting that when the negotiations for the criminal court started, the so-called preparatory conference, there wasn't just English and French, there was also Spanish. And when people were discussing about what languages should stay, how the language service should be organized, it was not experts were called from all over the world for the legal issues. But nobody contacted any language experts to find out about how much things would cost. And in the end, the Spanish language was actually taken out of negotiations at the very last round. So we could have ended up with 3 working languages, which would have, of course, made things much more complicated. As it is, we have 2 working languages, English and French. And everything we do, including administrative instructions, has to be translated into French. Usually they're written in English. The language part is encased, it is formalized in these documents: the Rome Statute, the regulations of procedure and evidence, how are things run in the court. When the court started, then we had the regulations of the court. Everything, when a court is permanent, everything has to be formal. We have to have the document so that everybody understands how things should be run. One of the things that I had to do, apart from participating in creation of regulations of the court, was to do the regulations of the registry. And I'm not going to bore you with the instructions, with the regulations, but just to give you an idea on how this process went, is that this was months and months of negotiations on what are the things that we should say in the regulations so that everybody knows what we mean. Should we explain what simultaneous is? Should we explain what consecutive is? And we did. But the regulations were a lot longer to begin with. I personally wanted to put in, for instance, just to give you an idea, that water should be provided. And of course, I had to fight, and I lost. For several years, there were no services that were coordinated properly. So interpreters did not have water bottles, not on time for the hearings or for the meetings. It took us a very long time to simply resign ourselves. Okay, the world is as it is. We cannot explain to people why we need water. And so we had a little stash of small water bottles for the interpreters. For the freelancers who came in, for the people who came for meetings, we just did it. Sometimes you just have to accept it and just get on with it. The registrar of the court at the time, who was French, he was absolutely adamant that water will not go in, and the water didn't. So that was the story of the regulations of the registry. Very recently, we had to review them, and then we also had to put things about videos, how videos always should be viewed 24 hours before, always should be provided with a transcript. And you know, it does make a difference. To have a document which says what has to be provided does make a difference. Why? Because if something goes wrong, you can say, well, we tried, but since there was a violation of Regulation 62, I know it's maybe a cop-out, but in fact, it isn't, because it's a permanent court. The ad hoc tribunals and the case of ICTY and ICTR are very good, because everybody talked about these are temporary tribunals. Well, when they exist for 20 years, how temporary is that? And they had decrees, they had administrative instructions, standard operating procedures, but they never went to these lengths. And I believe that you have to go to the lengths. You have to explain what are the rules that we want to follow in order to get good service, because it is about the service. Now, we get our mandate from these regulations. And the mandate is that we provide interpretation and translation, we provide terminology services, and the Office of the Prosecutor has a separate service, a small language service. This is an interesting development from the point of view of not all tribunals had a separate service, but it turned out that the languages are so important in multilingual courts. Then there is a real race to get the interpreters, to get the translation service. And this was thought to be a better option. Now, for recruitment of staff interpreters and freelance interpreters, there are two completely different things. The recruitment of staff interpreters happens like this. We have a vacancy and we have 5 qualified people. A lawyer is needed and 500 qualified people apply. There are too many lawyers in the world, that's all I can say. And I mean that in the best way. Why is that? Why are there no interpreters and translators? Even the management of the court don't quite believe me when I say, well, there aren't people. There are not. It's not an easy thing to acquire. And no, if you are bilingual and you grew up with 2 parents who speak different languages, you are not necessarily an interpreter. Yes, you may have been doing that sometimes, but this is a profession. Yes, it's a calling. Yes, it could be an inspiration, all of those things. But you actually have to know what you're doing. It's not an instinctive thing, although sometimes it can be instinctive. So the interpreters that we recruit come from all backgrounds. We have a very wide variety of nationalities. UN organizations or the type of the UN. We are not the UN. We are independent, but we are modeled to be like what is called the UN Common System. They always like to have a wide variety of people, and so we have something called geographic distribution, which means that people are encouraged, and you cannot recruit people from the same country. So you can't have 50% of people from the same country and so on. But the only service which is exempt is the language service, because of course people have to come from the countries where they are native speakers. So you can't have people from some other countries. And so, however, we have managed, because we have so many African cases, that we should have a wide variety, and it makes a big difference. Now, I'm often asked, which one is the best school? Who are the people that are best? Because we have Canadians, we have the British, we have, I'm trying to think, we don't have any Australians. We have French, where are the best schools? Is it ESIT? Is it ETI in Geneva? Where do they come from? And I have to say that I always get a lot of surprised people when I say the best school, according to what I see from where my people come from, is Buea in Cameroon. Now, why is that? That's something that nobody expects. Why is that? Yes, it is a bilingual country. They have French and English. They have truly bilingual institutions. The presidency, the ministries, they all have to do everything in the French and English. But the school in Buea requires all interpreters to do translation first. Now that is a very interesting twist on some people's belief that you cannot do both things at the same time, that you cannot be a good translator, good interpreter. I don't think there is a rule. I think there are fantastic interpreters who could not translate to save their life, and the other way around. But the translation practice gives interpreters the depth that they might not achieve by purely interpreting, by purely working on their interpretation skills. We do a test, and it's a competitive test. That means that people get all of the 5, and I'm only joking a little bit. We sometimes have 10. Are tested, and the test is, I think, quite tough. We usually they don't get any time to prepare the simultaneous test. The simultaneous test consists of legal interpretation, and it can also consist of a general interpretation. And then we have something which is always greeted by a lot of surprise, shock, and sometimes a little bit of anger. We actually give them a sight translation. And sight translation is my absolute favorite way of practicing interpretation and also translation. And it's so simple because you take a text and you just say it. They get 5 minutes to prepare, and sometimes we will give them, not sometimes, very frequently, we'll give them something literary. Because you need to be how can I put that? You need to be able to translate the culture that comes in literary text. You have to have the words. Plus, and of course, the stress is high. And then we want the people to do what the French say, sauver les meubles, to save the furniture, to see, okay, what is it that I can do? Yes, I cannot remember this word, but I'm going to use something else and it's all going to sound fine. Because we want to see that ability to come out and deliver under stress in competitive examination mode. Now we have used quite a variety of writers. And later on, the interpreters who did get the job did tell me about their huge trauma of having to suddenly translate Mauriac into English. But it did work. I believe that we do have a good quality of interpretation from the staff interpreters. Now, staff interpreters, once they are recruited, they have to learn about the cases. This is where preparation comes in. They have to know who are the people in the courtroom, what is it that they do, how is everybody going to be addressed, what are the roles of everybody. Now, for staff interpreters, that's not very difficult because they will be in the court all the time. What do we do with freelance interpreters? Now, freelance interpreters also, they will not pass a test because they are usually accredited by the AIC. And if they are AIC, which is the International Association of Conference Interpreters, we will not ask them to take a test. The interpreters who come to us as freelancers will have to work in the dummy booth for at least a day, if not 2 days. Because you cannot be parachuted into a trial. You cannot be in the booth. So if I'm talking about even simple witness, and I say simple in inverted commas, witness testimony, and even if you have a statement to prepare, it's still not enough. Because you need to understand the context. The context is everything. where does this fit into the case? Are you in the beginning? Are you in the prosecution case? Are you in the defense case? Could there be could there be an objection raised that there could be a legal argument about it? All of those things are important. So our freelance interpreters, once they have been security cleared, because clearly we have a lot of demands regarding security clearance, they will have to be prepared, and they will have to be thoroughly prepared. They come in, they have access to computers, they have access to the disclosed evidence, and they will work. When we get conference interpreters, and our interpreters are called court interpreters, and we have to explain always they are court interpreters, but they work in simultaneous mode. We have a little moment that might last for a couple of months where conference interpreters say, no, it's the same, no, it's the same, it's the same as court, conference and court, it's exactly the same. And we have to work on them. At a conference, if you make a mistake, you will gloss over it, unless it's something absolutely crucial and you have inadvertently offended the chairperson, and then you will say, interpreter corrects himself, but you will not make a big deal out of it. It'll be you will just surf over it and you will get to the point. You will not thank the chairman for 5 minutes in, let's say, as I have seen it and heard it in many conferences. Somebody will get up and they will say, dear chairman, what a wonderful presentation, thank you so much, it has been the most wonderful, and I cannot tell you how much the delegation is grateful. We all know what conferences are like. And the Spanish booth, and I have heard it, would say, muchas gracias. And that's it. And that, in that sense, is conference interpretation, because there is no need. Well, maybe some of them will feel shortchanged, but it's not an issue. Now, in court, everything matters. And words matter, yes, but of course meaning matters more. But words matter in a sense that if a witness says, yes, yes, the interpretation will be we. Not once, twice. If there is a negation that's repeated, it's got to be repeated. Now, occasionally, we have problems. And that is when questions are asked. And I'm sure practitioners among you know exactly what I mean. Especially when questions are asked in English or in French, which will require a nice little conjunction at the end, and they'll say, isn't it? And suddenly, you hear yourself, oh dear, should I say, is it n'est or n'est pas, or is it, what was the beginning of the sentence? What did I say? To compound the difficulty, we actually have real-time transcript. Now, you may think it's fantastic to have real-time transcript. We have court reporters in English and in French, and they will be, they constitute the official court record. And sometimes, I confess, to have looked the beginning of the sentence to see in French what was it, how did this question begin. And occasionally there will be a disparity precisely between the negation and the affirmation, and somebody in the courtroom will say, Your Honor, I think there's been a mistake in interpretation. And then, of course, it's difficult to explain, no, there hasn't been a mistake, we're using negation because the question was asked in that way, because in French and in English. And then, of course, you can do a short essay on the question, but you don't have the time. So, luckily, we do have our angel in the courtroom is called court officer. Court officer sits to the right-hand side of the judge in front, on the bench in front. To give you a quick idea, a courtroom at the International Criminal Court is full of people. And we always give everybody, the freelance interpreters, the people who come in, everybody gets a seating plan. You literally have to know who's who. A seating plan is such an easy thing to get. But in fact, you do need to know how people are called in an international setting. And even in an Australian setting, there are so many different names, and it's so nice to get everybody's name right when they're being introduced. And so there will be the judges will be sitting on the bench. There will be their assistants or associates. There will be the court officer, who's a member of the registry. Also, if I am the judge here, on my right-hand side, there would be the registry bench. The registry bench is reserved for such services as Victims and Witnesses Unit. I have been on the registry bench in the courtroom, being quizzed by the presiding judge on when will the translations be ready. It has happened to me 4 times, and it's not something that I wish upon anyone. I also feel that it was a very beneficial experience for me, because I always used to think that lawyers in the courtroom should really speak more slowly. They should articulate more, and so on. And then I found myself in front of a very stern judge, who is I'm remembering now, Judge Fulford, who left the ICC. Otherwise from the High Court in London, and he was asking me, and I started to giggle. I realized it's all very easy when you look from the booth, but it's actually really hard to be in the courtroom. And I think one of the things that interpreters should also understand, everybody's got a job to do, and everybody's job is got its own difficulties. The helpful audiovisual director, after this little scene, gave me the DVD, which is absolutely horrible because I keep giggling when I am being asked when the translation will be ready. And this is something that I cannot believe that I did, but I did because it's there. So this is something that even people who have the experience and know what they're talking about, well, things happen. So the accused sits further on the right, surrounded by security officers. We have the defense. The defense usually has a co-counsel, case manager. On the left-hand side, closer to the judge's bench, will be the victims' representatives. Now, what's very important in the ICC is the role of the victims is very different, or rather it exists, because victims don't really have a role certainly didn't have a role in other international tribunals. But here they can be represented, they can participate. And the definition of the victim is very interesting because it doesn't have to be a person. It can be a community, a school, a church, and therefore they can apply. They can be represented. They can apply to participate. They can apply for reparations. Now that's also a very different term to translate. Reparations does not mean compensation. So this is just an aside. That here, even in the very language of the court that we've been discussing for 10 years now, we still have certain things that we are not sure how to translate. Now, for court interpreting, for conference interpreters who come into our world, it's taken me, certainly for one very tenacious French conference interpreter, it's taken me 2 years to convince her that this is really different. And now she's a convert. So context, very important. We use fact sheets. We prepare who is who. We have to make sure. Sorry, I forgot there on the left-hand side there is the Office of the Prosecutor, of course. I should not forget the most important party in that sense, since without them there would be no case. So the Office of the Prosecutor, the public gallery is behind the bulletproof glass. And the interpreters are on the sides, so on the right-hand side, the left-hand side, and we will always have a French and English booth. And for the languages of what we call the situation languages, we will have Swahili, Lingala, Sango, or some other languages. Now, I think I've covered the context, the preparation. Now, when I talk about connections, one of my interpreters explained to me that he was greatly inspired in explaining his profession to others by referring to a Steve Jobs commencement address at Stanford some years ago, where Steve Jobs spoke about connecting the dots. And he said, he was referring to his life and how he dropped out of college and so on, and that now with hindsight, he sees that it's all connected. All the dots, in fact, everything that he did in his life was connected. But as my colleague interpreter said, interpreters have to connect the dots in advance. They can't look back. Of course, the looking back is important, but as we all know, if you're interpreting and you look back at what's just being said, you're going to lose what is coming. So you can't be self-reflecting, yet you have to be fully aware of what is going on and what might happen. And that anticipation, that is the key. And if the professionals who use interpretation services understood that an interpreter, to give its best, and I should say it's the good enough service, has to know what's going to happen next. If a prosecutor is going to ask a witness questions, and he can expect, he can anticipate what the witness will say, then he should give at least a list of questions to the interpreter. This is not something that's going to ruin his case. On the contrary, I spent some time at the ICTY explaining to investigators and prosecutors that rhetorical questions didn't work in interpretation. First of all, you want to have the surprise, but the surprise only really works if it is immediate. Also, as we know, a lot of people will understand a little bit of the language. And if we are to believe that 95% of communication is non-verbal, then I don't know what interpreters are doing, but of course the witness or the suspect will have understood that there is a sting at the end of that question. Now, you really want for the interpreter to know what's coming. You don't want your interpreter to be surprised. But this is a very, very steep hill to climb, because the concern of the prosecutors or the defense counsel is always that confidentiality issue. But what if this will be leaked? How are you going to use it? And the professionalism is the answer. There is a code of conduct. There is the oath that interpreters swear. And if we all have a common understanding of what is supposed to happen, then no one will be surprised and no one will speak about the prosecution strategy. Again, the same interpreter, a colleague of mine, is interpreting very intricately and with great difficulty a very verbose defense counsel. Now, he's doing that, and I have listened to both English and French, and I am amazed that the interpreter doesn't have the text in front of him. But what he does is that he becomes a little bit that person. He has interpreted him for several months, so he now knows that there will be an excellent way to showcase his own French, and it becomes a real joy to listen to both. And of course, this is for the language buffs. It's not for everybody that somebody is so amazed at how well it can be done. But the anticipation is the key. Is because he knows what's coming next. Here I am reminded of one occasion when I was interpreting. I was interpreting in the English booth, which means I went into the English language from French and from Bosnian, Croatian, Serbian. And this was a specific trial at the ICTY, the Galic trial, which was about the siege of Sarajevo, and it was always tough because there are witnesses, there are artillery incidents. We had very tough forensic ballistic specialists, and the judges would ask the questions at the end of a testimony. And this is the unknown. We know what the prosecutors are thinking, we know what the defense are thinking. We have seen the statement of the witness, so we know what the witness is going to say, but we don't know what the judges will ask. And this is where we are really tense, because anything can happen. And so this very slight, I can't remember the country, North African judge who spoke beautiful French, and in a very small voice, so I had to crank up my my earphone to hear him, was asking a very complex question with a variety of clauses and subordinate clauses, and I was struggling because I didn't know where he was going with it. And when you don't know where he's going, you are just filling. You are filling. I believe there is a word in linguistics which now escapes me on how you fill this. Anyway, I was doing that, filling, and there was this very beautiful, very intricate, but still there is no, where is the question, where is the meat? And then suddenly I got it. I understood where he was going with it. And overjoyed at it, I completely forgot what I was doing. And I suddenly exclaimed, "Oh, yes," in the middle of the question, to which everybody, since most of the courtroom listens in English, everybody turned around. What is this? What happened? What happened? And so I just I said, okay, I will bribe the court reporter later to erase that, which I did. I actually baked a pie for the court reporter. It's a true story, and she took it out since he didn't have any incidents on the trial, and that was how your brain gets separated. Half of your brain is listening, half of it is worrying about the meaning, and suddenly, of course, you can't control it all. The particular challenge that we face, of course, at the ICC is how many new languages can we have? And the answer is an infinite number of languages. We started very promisingly with training interpreters for Acholi. Acholi is the language of northern Uganda. And we were hoping, as I'm sure a lot of the world was, that we would get Mr. Joseph Kony and some of his accolades, but it didn't happen. However, we did train a team of what we call paraprofessional interpreters, and this was the term used deliberately to as to describe them as trainees, since the paraprofessional interpreters wouldn't have gone to interpreting schools, and we have even had to negotiate with our human resources that said, oh, well, you can't possibly have anybody called interpreter if they haven't gone. So this was a long negotiation process on getting them to recruit them as trainees after we tested them for aptitude, and then training them. And the most important thing in training was the terminology, because a lot of those languages wouldn't have the legal terminology, but it wouldn't have the simplest terminology, such as, for instance, victim. There is no word in Lingala for victim. You have to describe it. You have to say the person to whom something bad happened. A legal representative of victim would be the person who speaks for the person to whom something bad happened. So if you can imagine that an interpretation, when we're having Lingala, would go from English into French, and then French would be relay language for Lingala. Because for Lingala and for Swahili Congolese variant, which was used in all of the DRC, Democratic Republic of the Congo cases, we had to use the Congolese variant. Swahili being a fairly spread language in Africa, it's not. It does have different varieties, and it will always be influenced by the languages in different countries. So in the Congo, it will be influenced by Lingala, also by the French, and some of the words would still be used in French. Terminology was important in order to show, to make sure that we are all talking about the same thing. And sometimes it wasn't easy. We would get experts. You can't always get experts. We were very lucky to get experts in Swahili, in Sango. Sango is the language of the Central African Republic. We had the experts in it's all usually one in Lingala. But what was really important is to get people, speakers of the same language, together, because that's really, in a way, you can do without an expert, but you really have to have several practitioners, and they can discuss if a word used like this would indicate different things. Should we use this word for assault or this word? Is this too vernacular? Is this too formal? So these things have to be agreed on before. And for 6 weeks of any training of this type, there would be regular terminology sessions. And we would lead them without understanding the language, but it doesn't actually matter because they have to explain it, also in French, if these were the languages. So this is how we worked. And then we would come up with terminology bulletins, some of which I've given to the school, so they will be available. Now, quality monitoring. This is something that is always useful. Judges, the parties, court officer, interpreters. Who is the most important here? Well, it is the interpreters themselves, because interpreters always monitor themselves. They always listen to what they're saying. Although I have spoken always about single interpreters, it's really important to remember that interpreting is it's all about teamwork. An interpreter never sits alone in the booth. I have no idea how people go to the courtroom in national courts and just are standing there by themselves, because that is just not enough. It's not good enough. Not because that one person is unable to do the work, it's just that they will need to be relieved. They will need to have resting time. And so as one interpreter is interpreting, the other one will be looking at the documents. They will be waiting to see if something will come up. They will be writing down numbers, they will be writing down names, and if something comes up, then they will be able to open, and if somebody says, according to the regulation such and such, regulation will come out, it will be found, and the interpreter will be able to interpret properly by referring to the correct text. That's why colleagues are important. Also for court officer is the lifeline for interpreters to speak to the presiding judge. The parties will use it, as you can imagine. There was a mistake in interpretation, there was a mistake in translation, this is not what was said. This is something that is normal. So I think if it's accepted, it's a lot easier to deal with. It's not something that we love, but this is something that we just have to accept that it will happen. I will not have time, but we will have a time in discussion. And this is the role of transcript. Everything is transcribed. That means that what we try and do is to correct on the record, so that interpreter will say, and they will be encouraged to say, the interpreter corrects himself. The date was 27th of May 2005. They will always be encouraged to do that, because if we correct on the record, there is less to correct later. Now, I will answer questions. We will discuss about what is the best way to prepare a trial, and the best way is to have all the services present. So it's not just the interpreters, the translators, but also the audiovisual service, the transcribers, and we will be discussing how this can be done, and we're explaining the role of everybody. ICC hasn't started from nothing. We have learned the lessons from ICTR, the extraordinary chambers of the Cambodian courts, the special court for Sierra Leone, and the latest addition is the special tribunal for Lebanon. So we are a permanent court, but we are not alone. There are still very many ad hoc tribunals. Thank you.
Alex, thank you very much, and sorry for showing the minutes, and you finished actually ahead of time. I think what we have just heard is perhaps the beginning of a conversation, and what I suggest is that you I'm sure have some questions, and Alex, I'll ask you to come back, and Adela and maybe Sean, could you help us with the microphones? Yeah, so if you have any questions, please feel free, but I'll abuse of my role as a chair in order to ask the first question. I hope I'll be forgiven. One of the challenges in the Australian and other multicultural societies in training or achieving competence in interpreters, in court interpreters, is a question of preparation, training, and other prerequisites. So we are interested in interpreters. In Australia, the term is either rare languages or new and emerging languages, presumably standing for new and emerging community languages rather than languages. Since most languages used at the ICC are languages that are not in which you cannot train interpreters in either universities or other educational institutions. So what is your approach to get interpreters in these languages to the necessary level of competence?
One of our success stories, which may never come to light in terms of court, was our training of Zagawa interpreters. Zagawa is a small language with several dialects, and it is in the Darfur region of the Sudan. Now, because of the conflict, we had to recruit usually from the diaspora. And we didn't have very many. And the English of the candidates wasn't sufficient for us to feel confident about it. To make things a little bit more complicated, Zagawa is not a written language. Now, we really had no choice because one of the accused is a Zagawa speaker, and that is important. So it is the paramount, the right of the defense. What we did, and I have to tell you that we had a lot of skeptics around, is that, first of all, the decision was made that we would not go through English, that we would go through Arabic. So Arabic was chosen as a relay language, as more reliable, since their Arabic was better than their English. We proceeded to train them in Arabic in Arabic terminology, so to make sure that their terminology in one of the languages was absolutely perfect. Zagawa, there were no experts in Zagawa. If anybody knows of any, you'll have my details. And I think we found somebody who is in the States, but had a job and they were not interested. And there is another slight difficulty that some of the academics who have worked with those languages, international academics, they worked in Khartoum or would occasionally visit Khartoum, and if they were seen to be working with the ICC, well, that would have jeopardized their standing. So one has to remember that in the ICC we're still dealing not just post-conflict, but with conflict situations. And what we did is that we had no expert, we had a limited number of people, and so we proceeded to do a kind of adapted paraprofessional training, which would involve a lot more of Arabic terminology, and then trained them in every possible aspect of the court in English. So, what is it that Victims and Witnesses Protection Unit did? What is it that legal representatives of victims did? What was the Trust Fund for Victims? What was the prosecution doing? How were the investigations conducted? So what happens is that they were completely immersed in this world. And we did ethics and integrity training, and that on a regular basis. So they had a lot of Arabic terminology. They had all different parts of the court. And then, because there were not enough Zagawa speakers, we were ordered by the chamber, in that case, to assist the Office of the Prosecutor in the disclosure documents, to translate disclosure documents. Now, you may ask, how do you disclose documents when you can't write the language? Well, we did audio recordings. So, in fact, what happened is that we used the disclosure documents, we pulled the resources with the Office of the Prosecutor, since we were given permission by the Chamber, and we translated, so they worked on the translation. They were trained in audiovisual, so how to translate, how to stop the recordings, how to paste them. So what we did was that peer review was important. Because we didn't have many of them, they had to review each other. But in fact, if you explain, and this is a very long answer, if you explain to the interpreters or wannabe interpreters or people who are in training, what is the standard you want to get to? This is where your good enough starts, because they will understand. If you say there should be no omissions, there should be no changes, you shouldn't make it bigger than it is, you should make it smaller. And if you explain it like that, it actually works. So that we found that our quality was actually pretty good. So, well, I suppose we will only know how truly good it is once the trial starts. But this was our way, and of course another way, which was consecutive training, which was to because you can train, there are many different strategies, all of them a lot of fun, in training people whose language you don't speak, which is to use a story. And we had this, one of our trainers, who's very much into Japanese, he's learning Japanese, he loved this Japanese ghost story, which was incredibly complex and had a lot of details. So if you tell the Japanese ghost story, in this case, to one of them, and the other one isn't there, and then the other one has to tell to the one who wasn't there, and then you have to get it, then you find out what was missed. And we then deconstruct it and analyze it, and we work out exactly where the mistakes happen, which is incredible. And yes, it is time-consuming. But in fact, if you can make it, you can do it in a kind of modular way to make sure that if people know what's expected, they will comply. If you give them the final objective. Does this answer the question?
Thank you. Any questions? And we have a microphone there.
Yes.
Okay. Adela?
I sit or I stand? I sit better because I'm a little bit ugly to stand up. Not good looking, maybe follow you.
As long as people can hear you.
Hello? Hello? Hello?
Yes.
Good morning, ladies and gentlemen, all officials, all important people. My name is Woody Chamron. I am Cambodian interpreter, Cambodian in English, but my race is Khmer, Khmer. And first I want to know, can I apply to work with ICC? Because you have learned not do, sorry. I have learned that ICCC in Cambodia is a disaster. That's from my personal opinion. The world spent 150 million US dollars, but the system of judging is biased toward the murderer. Okay. Now, can I apply to work with ICC? I'm only para-professional. And second question is, I learned that as a para-professional, I'm interpreting the facts, not the emotion. And I have some small experience in 1992 when the Thailand got coup d'etat. I went to interpret, and they asked, what's the name of the coup leader? And I knew I can speak Thai and Cambodian fluently. I said, sorry, I don't want to work anymore. If I mention name, I may be in trouble. So I withdraw. Then they punished me that not employing me anymore in 92. And in Australian official government, they call, I should not mention name, okay, official. They said, oh, Mr. Woody Chamron, can you interpret Cambodian language? I said, excuse me, sir, what language? Cambodian to English. I said, sorry, I don't want a job. I'm going home now. I said, excuse me, it cost us 20,000 the trial today. You have to do it. I said, no, I never heard Cambodian language. Khmer language, yes. In English, Cambodian language, yes, I can do it. But Cambodian language, no. I know. This is political influence. I withdraw back. That is, and another one, in court.
I'm very sorry to interrupt you,
Oh,
but
sorry.
what was the question?
The question,
Yeah.
can the political influence to the court, and the court still continue and take money from the whole world, and the justice not has been done to Cambodian people?
Yeah, but thank you for your question. But the thing is, this is not a political discussion, and it's not even a discussion about the justice system, international jurisdiction. We're talking about interpretation. And
Interpreter, because the interpreter influence from the other country, and one day I just come back, they interpret wrongly because influence. You have to say it, but when the judge or the Dutch people, the German people, English people, French people, when they say blah blah blah, and interpret wrongly.
yeah, well, I'm sorry, I'm not familiar with the case, so I wouldn't.
Okay, I will go with you because ICC is biased. You try to give justice to Cambodian people. 3 million got killed, but in fact you put more pressure. You could put more killing to Cambodian people. Why do you spend money, the world money,
Yeah.
to put more
Sorry,
suffering to Cambodian people? ICC. And very soon, we already put on 24th last month, we put to ICC. We put application to ICC.
Yeah,
already.
I'm not sure that the ICC is involved in this. It's not the same
No,
court.
24th of March, about the Prime Minister, he killed so many people.
Yeah.
Okay, 24th March, we put
Okay.
application to ICC already.
I think we want to talk about interpretation.
Yes, interpretation is
Yes.
biased. How can we just leave the interpretation, listen to the people giving the money? They say this is black, but
Yeah.
no, don't say black. You must say white.
Yeah,
Like,
but
you
we're not
don't know.
we're not talking about biased interpretation. We're talking about objective interpretation. Okay.
I don't know how to ask them.
Hi, I'm Sylvia Martinez, Spanish-English interpreter, and have worked within court interpreting in Australia as well. Extremely interested about everything you've said about the preparation of interpreters and even fighting for water. What a noble thing to do, and what a shame you couldn't get into the regulations. Specifically, I did want to ask you about further, when you talk about the school, I wasn't quite clear when initially when you talked about training and terminology, you said about developing resources that were then used in the school.
Yes, I meant I brought them for the school here.
Oh,
Sorry.
excellent.
So I have got some terminology bulletins, and I will explain how we did them. Because what it is that some of the terminology bulletins are, although we want to be an e-court, and a lot of them are available online. People don't believe they really exist until you give them books. So we have those, and that is great, a huge help. So I will show you. Yes.
That's fantastic. Thank you. And I just wanted to ask you about when you are involved in that preparation for specific cases. How much time do you actually have for the training of interpreters in new languages?
Right. We have done training. In 6 to 8 months. That has been our time. Usually trials don't start on time for whatever reason, and that has been a blessing, because that would give us additional time. In one of the cases, the Lubanga case, there was a stay of proceedings, which went on for a while, and that allowed us to get even more training. So these things help, but we have to have a minimum time, and we call this 6 to 8 months.
My name is Michael Getting. I'm the Principal Registrar of Credit Law in Western Australia. Can I ask a question about courtroom design? In your interpreter booths, do you have line of sight to every speaker? And if you can't do that, is it good enough to have good quality audio-visual feed?
Yeah, we have. You can't have a line of sight to every speaker, because you would have to be everywhere, because the way the courtroom is designed. So let's say if this is the bench, and you have the parties there, and the booths are on the sides, then they will only really have a direct line of speaker to the bench and to the other side, but they will see the back of the backs of whoever's in front of them. There are 2 screens in every booth. And the screens, you can click whether you want transcript, which transcript you want. If you want, there is an audiovisual director for every hearing who's filming, and they will be filming the speaker, so you can always have the speaker on the screen. And in fact, the courtroom is relatively. Well, it's not maybe large. I have seen some of the courtrooms in Australia, and I think it's very hard to say whether it's large or small. But in fact, the interpreters are quite high, so they really look at the screens. However, it's always good. They might look out to see if somebody is standing up and who's not on camera, because standing up means somebody will speak, which means that's the anticipation I was telling about. But yes, it's good to have the audiovisual. Is really important to have a good screen, good resolution. It really helps. There are in some large institutions, such as the European Parliament, they have screens that are even larger than this, and they are split. So you would have the speaker, the whole of the area, and so on. So that way, it's even easier. And also, of course, when interpreters can choose what they can look at, that's the best.
Hello, John Benson, I'm also a French interpreter. Just in terms of the dirty commercial side of things, in Australia we have a very dysfunctional market for court interpreting in terms of remuneration. I was just interested to know if you could give us an idea of the average day rate that you would pay a contract interpreter for a day's work in court. And secondly, could you confirm, I think what I took from your presentation was that you said that to maintain quality, having a sole interpreter working all day by themselves in court is completely unacceptable. Is that correct?
Yes, that is correct. When we have freelance interpreters who come from the AIC directory, they are paid according to the AIC world rate, which changes. And I'm trying to remember. I believe it's something about around $500 US. It changes, and that would mean that a person would come and interpret. It could be an hour, or it could be a whole day. So that is the rate, and this is for all international organizations, and they do not pay tax on that. International international organizations which are within the UN system have the ability to issue tax exemption certificates. So that, by the way, dates way, way back to the Ottoman Empire, when the dragomans, who were called, I believe, one of the curses of Constantinople alongside pestilence and the plague, they were known to also they were also tax-free dragomans, but they could really quickly lose their head if they went. So I think there's as far as your question was, but for court interpreters in that sense, we would get, for instance, we had occasions when we had languages for which there were no interpreters. So that would be in the case, I'm trying to remember, I believe it was in one of the cases called Katanga and Gujolo. There were two languages that we could not provide simultaneously, Alur and Lendu. And what we did is that we have accredited field interpreters for those languages who work in consecutive. So one of them was based in Belgium, the other one was based in the DRC. So we brought them for, I'm trying to remember, about 10 days before the hearing. They were trained, they were shown into the courtroom, who's sitting where, everything. And I think that the rate was about, I think it would have been about $200 US. So that's a lesser rate because they're not, it's not the same, it's not the same. But what was important is that one would not have worked. It simply cannot be done with one. That's how we've decided. Even the simultaneous interpreters change every half an hour on the microphone. And when we had our two colleagues in Alur and in Lendu, they were working in consecutive fashion, but they were also switching, and we thought even half an hour was too much, so 20 minutes. All consecutive, so normal court interpretation in national courts adds, if it's just one language, 30%. That's how we calculate. So so it has to be acknowledged that it takes longer. Yes.
More questions?
Normally I don't need it, but it's fine. I'm Rod Shelton. I'm a trainer of investigative interviewing, or my apologies to Mr. Cowdery, forensic interviewing. And I was at a conference last year in the Netherlands where a couple of your compatriots gave a talk on the difficulties of field interviewing in some of the African countries. And specifically the conference is through the International Research Group on Investigative Interviewing. And we're sort of looking now at the pre-court arrangements, the pre-court interview, as in then being such a standard that really the court can sort of be bypassed. And it is happening in criminal investigations, criminal matters in Australia here, where if they, pardon me, an investigator does such a good interview that the prosecution and the defence just accept that interview, and then there's no court interviews that happen. Do you see this happening in the International Criminal Court?
Yep.
One of my ex-compatriots, and an ex-Queensland police officer, is currently an investigator with your group in Africa. He's been there most of the year and everything. He's trained in this method, and he's finding that now the interpreters have to be trained. The interpreters have to be trained in the modern peace method of interviewing, the forensic interviewing, otherwise they end up with difficulties during that interview.
In the ICTY, this procedure existed. It was called 92 bis, and this was one of the regulations. One of the rules was that it could be so that the statements would be accepted without viva voce testimony. For the ICC, we do train interpreters that work in the field. and they are accredited, and they are not going to get the accreditation until they have been trained. That means that they will be, apart from getting the testing and interviewing, security screening, they will also be trained. We have a 4-day, which is now going to be extended to 5-day training in how to avoid having any problems, but also how to say when things are not clear. Because what I have seen over the years is that in some interpreters, especially on mission, that means in the field, in difficult situations, they feel that they don't want to say when they haven't understood something, or they feel reluctant. So they are not sure exactly what the military rank of the person is. So they will use some other word which is approximate, or instead of saying whether, if they can't remember whether it was a brigade or a detachment, they will use the generic word unit. And these things happen. And I think that's what we're trying, we're working on that, so that people are able to be accurate in a productive way, including correcting themselves and or asking for clarification. But yes, it is teamwork. An investigator and an interpreter together put together a statement. And that statement, I used to compare it to a boat which is then sent on the seas, and it has to withstand the storms. And if it's good enough and it ends in the prosecution file, and it can be used, but otherwise it might perish if it has a lot of gaps. However, the responsibility, having worked with a lot of Australian investigators with the ICTY, I know that the onus is on the investigator. She owns that interview. And if something is not right, they have to stop the interview and have a talk with the interpreter. There could be moments when, and we have discussed this specifically with specific reference to traumatized witnesses, that the investigator might want to pull back. But then the control of the interview might be handed to the interpreter. If the investigator and interpreter work well together, the interpreter might be given, but it comes mindfully, that the interpreter is given the chance to have a chat with the interviewee on whether they're feeling okay, would they like some water, would they like a break, that kind of thing, to establish rapport. But there is no relationship in that sense. There is no, it is a relationship which is encouraged by the investigator in that sense if the witness is traumatized. And this is something that we've also worked on with a lot of the investigators at the ICTY. It is a case, of course, with sexual violence victims, with people who have lost family. It's very important to have that ability. But it's really, again, teamwork.
Are the interviews recorded? Are the interviews recorded so that the interpretation can be checked
yes.
later on? And what basically we promote that all interviews, witness or suspect interviews, be recorded.
Indeed.
So that the police officer, and that's the area that I look at
yes.
now, has to do
yes.
a great job.
Yes, I agree. It will not be played in court necessarily, but yes, at the ICTY, they did not record the interviews. Everything was on paper, in English, usually, or in French sometimes. At the ICC, they record everything, and I think that they've learned. It's a kind of they've learned also from the mistakes of the other tribunals. So yes, everything is recorded. I agree with you. The recordings of the suspects were always done at the ICTY. And yes, they were checked, they were transcribed, and they were also quality checked. And I remember one particular moment which I cherish, when a colleague at the ICTY was checking precisely what you say. And the question of the investigator to the witness was what uniforms were the soldiers wearing? And then the interpreter interprets that correctly, and the witness gives the answer. And then the interpreter says, "What about hats?" It's completely irregular and not for the interpreter to ask that. So yes, I agree with you in that sense. Yes.
In the form of interviewing, that's a leading question. It's not good.
Yeah. But that's yes.
Hi, I'm a member in Victoria working in the court interpreting department. I saw in one of your slides there was a preparation listed there. I'm wondering, while you work in RCC, what sort of preparation were you given in terms of time, how long ahead of the Congress or trial, given the materials, and how much information or what sort of form of the document you can access before you actually start the
Yes.
trial or interpreting assignment. And my second question is, from your understanding about the current court interpreting in Australia, what sort of preparation do you suggest for interpreters to access?
Thank you for your question. Interpreters get about 1 to 2 days to prepare if they're completely new. So if they're freelancers, if they've never worked for us before, they will get 1 to 2 days. If they have been to the court before and worked on a regular basis, then they will be given maybe half a day to not interpret but sit in the booth and listen to what is going on. When you ask what material, everything there is. Interpreters are employed by the registry of the court. Registry is the neutral administrative organ of the court. Interpreters are sworn. They've signed the oath. They're not going to run off with the information. It's very important to know to know the case to be able to interpret. As far as it's very difficult for me to give any answer regarding the national courts here, but I think that certainly it would be possible to get some kind of electronic repository for the documents. For I'm sure it exists to have access for those who will be providing services to the court. So for me, that would make sense that a preparation can be just reading about the case, which frequently it is, and that anything that's public, the disclosed documents should be accessible to the interpreters.
I'm afraid we have to pause for tea, and I'm sure that throughout the day you will have the opportunity to approach Alex and talk to her. And just before we give her a vote of thanks, I'd like to remind you that tea is served downstairs. You have to walk, I think, 1 or 2 levels down. I also want to thank our Auslan interpreters who will continue and express a hope that our colleagues who are following this event through streaming from Western Australia and other states have been following us successfully. Because I think from our perspective it's a bit of a one-way street. So Alex, thank you very much for this wealth of information, and we'll continue.
Is this me?
It's yours. Angela, thank you very much.
Let me see if I can pause the recording.